it's not grounds for the case to be overturned or a new trial, then, you know, heaven forbid. I mean, it just opens a Pandora's box. I mean, I just can't wait to see prosecutors and defense lawyers in the future arguing, you know, about for or against this point, because it's just grossly unfair. I mean, it just takes away any semblance of integrity to the system when you can allow jurors to be emailing each other back and forth, both before the trial was over and I understand even during jury deliberations there was some of this going on. It wasn't going on in the jury room itself, but on emails between a couple of jurors.
Well, if you're just joining us or recently joined us, we're speaking with Julian McPhillips. Julian, can you give us some examples about maybe some of the emails? We're not talking here about what you're going to prepare for dinner or what have you.
I'm just looking at something I was handed examples of this, and I guess a lot of this has been it's public record, but it exhibits attachments to documents. But here's one from it says, from one juror to another. It says, I agree some of the counts are confusing to our friends, etc. Check text 33038 still off, etc. Another one. So it says the judge is really helping with the jurors or something like that, and different, and it goes on. It says still having difficulties with number 30, et cetera. So it just goes on. These are among the examples, and there are some others. I want to be careful. I don't want to say anything that
Correct.
would be out of you know, improper. But I would say that to me, some of the things I've seen on this list, this is just one of many examples were some very improper deliberations.
Well, maybe we can go into that a little bit more later too, but from what I'm gathering from what you're stating and what is said here on this list, you have jurors talking about possible evidence and maybe bringing in extrinsic evidence.
Right, and that's just, everybody knows that's wrong and unfair. In fact, I'm really surprised that, you know, I have a lot of respect for some of the U.S. attorneys that they themselves did not join in with the defense and say to the judge, yeah, you know, it's a lot of time on the trial, unfortunately, but we cannot let stand this as a precedent.
Well, I might say now, if I remember correctly, their position was that these emails were manufactured for this particular motion.
I don't know. I mean, I don't know what their response was, but it's just highly improper, and I would hope and have expected the U.S. attorneys to have joined in with the defense lawyers on this motion and saying it's just very wrong to have this sort of thing going on in trial, because it just totally debases and corrupts a trial when you can have this kind of thing going on. I can't imagine that the 11th Circuit will let it stand as precedent.
Well, that's something I guess we'll find out shortly once that motion is filed and or the appeal is filed on that particular motion. Yeah. A few more seconds left, if you can
well, let me just say this. You know, Richard Scrushy founded a company that said from ground zero that created thousands of jobs for people in this state. He also has given, you know, so much to charities over the years. I mean, he has not been treated right in this matter. He really has not. And Don Siegelman, on the other hand, has given so much of his life to public service. They both have been just treated awfully, and I hope the public understands that.
Thank you very much. Watching Special Report.